ACLU present family law and the LGBTQI community. My name is Mike Doherty. I'm a second-year law student here at the University of Montana School of Law, and I'm vice president of Outlaws. Outlaws is a student group here at the school whose mission is to promote awareness of legal issues surrounding the lesbian, gay, bisexual, transgender, queer, and intersex community. We also promote tolerance at the University of Montana. Our co-sponsor, ACLU, is the UM School of Law's chapter of the American Civil Liberties Union. ACLU is a nonpartisan, nonprofit organization whose stated mission is to defend and preserve the individual rights and liberties guaranteed to every person in this country by the Constitution and the laws of the United States. I just want to remind everybody that Outlaws and ACLU are both volunteer student groups. We are 100% student-managed and student-run. We have a great panel tonight. We have 4 outstanding attorneys and 1 outstanding student. Professor Cynthia Ford will serve as tonight's moderator. Professor Ford graduated from Cornell Law School in 1978. Before joining the faculty here at the school, she practiced as a trial attorney in Montana and Washington State. Professor Ford has published extensively on the issues of civil procedure and evidence. In addition to also teaching these subjects, she also teaches family law. Our next panelist is Evonne Wells. Evonne received her law degree from the University of Montana in 1986. Upon graduation, Evonne immediately opened up her own practice here in Missoula. Her practice is now known as Wells and McKittrick. Evonne, like all of our panelists, have extensive experience in family law, having tried hundreds of family law cases. Like Professor Ford, Evonne has also taught family law here at the school. Next to Evonne is Susan Ridgeway. Susan graduated from the University of Montana School of Law in 1990. Upon graduation, Susan went on to serve as a judicial law clerk at the Washington State Court of Appeals, and then as a Washington State Assistant Attorney General before returning to Montana. Upon returning, Susan was also an associate at Dasopoulos, McDonald, and Lynn before opening up her own practice. Susan practices in many diverse areas of law, including family law. To the left of Susan is Julie Brown. Julie received her law degree from the University of Montana School of Law in 2011. Immediately upon graduation, Julie co-founded Montana Legal Justice, PLLC. Montana Legal Justice is a general practice law firm with the purpose to serve people of moderate to low income by offering a sliding scale fee structure based upon income. Julie also works with families in the context of dependency and neglect cases through the Office of the Public Defender. Our next panelist is Emily Lucas. Emily is a third-year law student here at the School of Law. Emily has served the LGBTQI community through her clinical and volunteer experience with a particular emphasis on domestic violence. Recently, Emily was awarded the Montana Bar Association Pro Bono Student of the Year Award and the Missoula Family Violence Council Citizen of the Year Award. Now, before I hand the mic over to Professor Ford, if there's any attorneys here in the audience that would like to get CLE credit, we have some sign-up sheets in the back, and make sure to fill it out completely. With that, I thank you, and please join me in welcoming Professor Ford and the members of tonight's panel.
This is such an exciting panel to be able to participate in. Thank you. Can you hear me all right back there? Yep. This is such an exciting panel to be able to participate in. I did notice while I was reading everybody's bios that I have been out of law school the longest. And I'm pretty sure that we had somebody in our entire law school class who would have fit into somewhere the LGBT community, but man, that was not going to be visible nor spoken about. So this is really in our lifetimes has become so much more open, and this is such a great thing to talk about. Family law, as you know, affects everybody, and it affects everybody so intimately. And there are some areas of family law, I think, that are reasonably well settled. For instance, it is no longer the law that the mother always gets the small children. But even in those situations where the law is reasonably well settled, the impact on the individual people is so immediate and so important that the whole deal is gut-wrenching. And then we get into areas of family law which are not at all well settled, and that's really where we are tonight. So all of these things that we're talking about, everybody on the panel has had some actual experience with, but we don't know the end of the story yet. Being able to have this panel is an important step in going further in that story. But nobody here has the final answer on every subject. But we all know that these are subjects coming up daily in practice for our clients and for we as lawyers. And so we want to share that experience. We also want to hear from you. So each person has already said, and it is not true that it is only women interested in this issue. It's just we haven't had one. But each participant has said that she would welcome questions and comments midstream, and then at the end we will adjourn and take questions from anybody here. So we want this to be a participatory thing. You get 2.5 free CLE credits if you are here and you are a lawyer doing CLE credits. So that's a screaming deal in and of itself. Thank you for organizing that. 1.5 hours of those are ethical credits, hard to come by, important to talk about. So we'll be talking about those issues as we go along. So what we decided to do was not in order of seniority, although it works out that way. Evonne, who taught family law last year, has got a presentation on the screen. So we started off with her so we could get that going. And she's going to start, first of all, generally talking about the future of Montana's prohibition on same-sex marriage and associated issues. And then Susan is going to talk about parentage for same-sex couples in the context of adoption, artificial reproduction arrangements, rights of non-parents and de facto parents. And then Julie is going to talk about legal issues in limbo. Is that right, Julie? Legal
Something
issues.
like that. It's, I'll explain when I get up
explain
there.
it a little bit more. But really, and some things including what happens when, with regard to adoption and legal parentage, when a lesbian couple does not use a sperm bank to conceive a child, and then also look at what legal issues will remain in, here's the in limbo part, even if marriage equality were the law across the United States. And then lastly, we're just really happy to have a student just embarking on her family law career. Emily's a third year. Emily would like to live and work in Missoula after she graduates. Emily would like a job. Ask one of those to Emily later. But Emily has been really helpful with the LGBT community through both her clinical and her volunteer experiences. So we're going to have her go last. Is that all right, Emily?
Yes.
Great. Excellent. Thank you, Evonne. Thank you.
Okay, well, thank you for inviting me, Mike. Mike's father and I went to law school many years ago, and Mike was actually in diapers when his dad and I were roaming the halls of the law school, which wasn't nearly as nice as it is now, but it's great to see you in this capacity, and thank you for putting this together.
Thank you.
It's a fabulous thing. I don't think you can really start talking about what's going on in Montana without really knowing what the status is across the country and what's happening so far. And so I found this.
Can you
this
turn those
map.
front lights down a little bit so we can see?
Yeah, I can do that. That's in my skill set. That is in my skill set.
So what this is the legal status of same-sex partnership in the United States by state. And the key down below at the top starts out in showing states where same-sex marriage is legal. And you can see those are the dark blue states, and they're centered around the Northeast, some of the central states, and then you see in our neighborhood, Washington and California. And then it goes down from there, the second little bit lighter blue, and I'm not sure I see any of those that are solid, but some of these that are hash marked, part red, part blue, part gray, those, the blue designates states where domestic partnerships or civil unions are allowed, granting privileges similar to marriage for same-sex domestic partners. Then we get down to limited enumerated privileges granted by states. So some states allow some privileges of marriage, but not all. The gray shading, and again, you see that in Oregon, part of that is same-sex marriages are performed in other states are recognized in the state of Oregon. So you have some states who may give full faith and credit to same-sex marriages that come in from out of states. The white states are no prohibition or recognition of same-sex marriages or unions in territory law. I don't know which that one is. The orange, judicial ruling against a same-sex marriage ban, but those bans are stayed pending appeal. And you see a number of states right now, including Michigan, and then originally when I saw this, I thought that Michigan wasn't updated, but I noticed it is. That just came down this past week. And this map's really fun. It's actually available in Wikipedia, which I've never used really as a resource before, but it appears, it's not something I think you cite, but it appears that they keep this updated very regularly. So it's a great place to go and just check out the status. So we look at Montana. Montana is the lighter shade of red. It's the second from the bottom, and it provides that there is a constitution and statute that currently bans same-sex marriage. So that's where Montana is today. And the only states that are more restrictive are those in the dark red, and I know it's hard to tell the difference, but Idaho is one of the darkest ones. That's Constitution and statute ban same-sex marriage and also banned civil union types. So Montana does not ban civil unions. It doesn't specifically codify them, but it doesn't specifically ban the civil unions either. So that's where we're at today. 17 states now have legalized same-sex marriage. Interestingly, 8 tribal jurisdictions have issued marriage licenses to same-sex partners. One state, and that was Oregon I mentioned, recognizes marriage performed in other jurisdictions. That's a state that doesn't recognize same-sex marriage in-state, but will recognize out-of-state marriages. And again, 3 states have recognized limited rights. They're similar to marriage rights. Interestingly, Utah now recognizes same-sex marriage for purposes of filing 2013 state income tax returns. But that's it, and I think that might have been a response to the Windsor case that allows same-sex partners to file tax returns as married couples. All right, so then we talked about those states where the U.S. district courts have determined and declared bans against same-sex marriage unconstitutional. There are 5 states now where these rulings are being stayed pending appeal. And so what we're seeing is this is happening almost a snowball effect, where cases are being brought in U.S. district court and same-sex marriages, that constitutional or statutory prohibition is being set aside as being unconstitutional. So what happens is the morning after the case is decided, the courthouse is flooded, and there are literally thousands of people lining up to get their marriage license. And then the state comes in and asks that this be stayed, the ruling be stayed pending appeal. And so we've got those 5 states now. And I think that brings up an issue that we'll have to talk about later. And that is, what do we do with all those marriages that happen in the meantime if the statute is later overturned, or excuse me, if the ruling is later overturned on appeal? Recently, in March of this year, March 14th, there was a U.S. District Court in Tennessee issued a preliminary injunction against the state of Tennessee, ordering it to recognize same-sex marriages that were performed out of state. So again, this is part of the full faith and credit clause, and normally we have full faith and credit. So let's talk about how and why full faith and credit has not been recognized across the board. Well, the first case that actually recognized or overturned a constitutional ban on same-sex marriage came out of the state of Hawaii in 1993, and that was the Bear case. Things have changed a lot since 1993, but after that 1993 case, politicians, especially in I think Washington, became very concerned about that case because the floodgates were going to open and people were going to start wanting to recognize same-sex marriage for purposes of obtaining federal benefits. And as we sit here today, the last time the GAO office counted up all those benefits that married couples receive, there was over 1,100 benefits that married people have that unmarried people don't have. And of course, those range from Social Security, retirement benefits, right to visit in hospitals. They're just all these benefits, and nobody really knew what the impact of that was going to be on the economy. So, interestingly, John Boehner was on this committee, and they decided that they were really going to challenge that statute, and so they presented DOMA, which is the Defense of Marriage Act. And interestingly, DOMA, are y'all familiar with DOMA? It's federal legislation, and it provided a couple things. It first provided that states did not have to recognize same-sex marriages from another state. So it was essentially an exception to full faith and credit. That was one part of DOMA. The second part of DOMA, or one of the other provisions of DOMA, was that the federal government would not recognize gay marriage or same-sex marriage. And so DOMA was in effect and is still partially in effect. In fact, the full faith and credit portion of that has not been overturned. But as most of you probably have read, the article that applied to the US government not recognizing same-sex marriage has now been overturned as being unconstitutional. And that was the Windsor case that was decided about a year ago. So part of DOMA is set aside, but not all of it. And so states still have the right under DOMA not to recognize out-of-state marriages. So again, we just had this case now in March. I think that was Tennessee or Kentucky. This case just came down and said, you know, that is really unconstitutional. And so again, this is sort of like the domino effect. And as you can see by the map, this is all coming and happening very quickly. And it's a very dynamic and exciting time in the law. You know, in the almost 30 years that I've practiced, I can't think of any issue that has been so in the forefront and so dynamic and changing as this had. I mean, what we had when we were in law school were the abortion rights cases. And, but Cynthia, I don't recall, but it seemed like that maybe happened overall across the board in the country. I don't know if you remember that, but this just seems like it's sort of more on a state-by-state basis.
Yeah, I remember that clearly, yeah.
Yeah. Okay. I thought I was old.
Yeah, really.
Oh, sorry about that. All right. Could somebody turn the lights back on?
Yeah, I can do
please.
that.
Thank you.
I know, it gets a little
Now,
light
that's-
clubby in here when you turn the
Yeah,
lights on.
and, I just got my new bifocals, so
Yeah, we want you to get hurt.
I'm doing better, but. All right, so how do we legalize same-sex marriage? either by court rulings, and as you can see from the map, those blue states, not all of those states codified same-sex marriage. Not all of them had a constitution that allowed it. In fact, California had a referendum in which the popular vote voted that they did not want same-sex marriage. They wanted marriage to be defined as a marriage between a man and a woman. But case law, and again, the Supreme Court of the United States ruled that referendum and that ruling was unconstitutional. So now California shows up as a same-sex marriage state as being legal in that state. So a lot of these cases we're finding same-sex marriage being legalized through court rulings. And it seems that that is probably the most prevalent way that we're going to see same-sex marriage come to Montana. The other way is legislative action. And interestingly, in preparation of this, I tried to call some of my legislator friends to talk about this, and nobody really wanted to talk about it. And when I was looking at the research and the platforms for the parties, I noted that in the last presidential election, the Republicans actually supported a ban against same-sex marriage, but the Democratic ticket was silent. So, you know, the popular vote is pretty close. Back when Montana, getting back to Montana, we had actually Initiative 96 back in 2004. And at that time, it was a referendum, an initiative, and it was to determine whether or not only a marriage between a man and woman would be valid or recognized as a marriage in the state. So that was put to a vote of the people, and at that time, 67% of Montana voted yes. A marriage is a union only between a man and a woman. And for many, many years, that's been codified in Montana law as well. Section 41103, that particular chapter provides marriage is a personal relationship between a man and woman arising out of a civil contract to which the consent of the parties is essential. And again, prohibited marriage is also determined to be prohibited marriages are marriages between persons of the same sex. So we have this ancient statute and then put it to a vote of the people, and only, you know, I guess only 10 years ago, in terms of this law, that's a long time ago, but 67% of the people wanted to keep the definition the way it was. So there have been some studies and there have been some surveys done recently. Right now, there is no referendum pending to change the definition or change the constitution in the state. There's no legislation pending to get rid of those ancient statutes. And I think people are sort of waiting to see. I think, you know, when they do the referendum the next time, they want to make sure it's going to pass, you know, to try to make same-sex marriage legal, or the Supreme Court is going to end up ruling on this and they're going to end up telling us all what to do. Although you have to note that in Montana, we don't always listen to what the Supreme Court says. Case in point, the deviant sexual conduct statutes that were on the books of the state of Montana until 2013. I mean, those statutes had been declared years ago to be unconstitutional, but Montana, like everything else, is a little slow to come around. I mean, we still have 3G, right? So it's just a little slow to come around, and just because the Supreme Court decides something's unconstitutional doesn't necessarily mean we're going to change our statutes instantly. But the most recent surveys, MSG Billings did a survey in October of 2013. And they, at that particular time, their study, I think they did 450 people with a margin of error of 5%. which is kind of a big margin when you're talking about surveys. So they determined that 46.6% of the population today supports same-sex marriage in Montana versus 42.6% who oppose same-sex marriage. And then 10.8% of the population was still undecided in their survey. So if a referendum were going to be done now, I think, if you look at these surveys, it's really a toss-up, and it's probably a close call and a close election. Okay, so we talked about same-sex marriage can happen by court ruling, it can happen by legislative action, and it can happen by referendum or vote of the people. So Montana, where are we? Again, no referendum pending, no legislation pending. Interestingly, Montana, Julie can talk about this more, because she's much more of an expert than I am on this, but Montana is the only state, or one of the only states, that doesn't currently have a case pending before it that is trying to rule our Constitution and our statute unconstitutional for banning same-sex marriage. What we do have is a case that the ACLU brought a couple years ago. Again, Julie was more involved in this, and I'll let her talk about it more in detail. But it's the Donaldson and Guggenheim case versus state of Montana, in which six or seven, I've seen it both ways.
Well, because it started with 7 and it turned out to be 6. Yeah.
They actually sued the state of Montana for failure to offer legal protections in what these couples felt were fundamental rights that they should have. They wanted protection as domestic partners and argued that they have right to equal protection in all affairs that relate to state law. So Guggenheim went up, they actually filed a motion for summary judgment. The district court tossed the case out. It was then affirmed in part, remanded in part. Interestingly, remanded to allow the plaintiffs to amend their complaint. And then, so that's where it is right now. I'll let Julie talk more about that when she comes up. But we are one of the only states right now that doesn't have a case pending to determine that the statute and the constitutional are unconstitutional. So again, a little slow to come around. But that's where you all come in, especially you young people. I want to talk just a little bit about private practice and what we see in terms of representing same-sex couples. And I've been doing this for a long time, almost 28 years. And I saw most of it when I was sitting in on the bench in justice court. And the reason being, if you don't have access to marriage laws, you have to resolve your property disputes somewhere else. And so you revert to partnership law, or you revert to joint ventures, or equitable theories of restitution and those kinds of things. So I saw a lot of cases coming in through justice court. As I've practiced, people are, I think, more intelligent when they enter into larger term business transactions and financial transactions. So what we are doing today is we create agreements for same-sex partners similar to a prenuptial agreement, but not a prenuptial agreement. Sometimes we call them a cohabitation agreement. Oftentimes we have agreements with regard to real property. Who makes the down payment? How are we going to title it? What happens if this relationship goes awry and someone has to leave and either buy out the other or be responsible for the mortgage? So in practice, that's how I am seeing same-sex relationships treated. And again, in preparation for this, I was talking to some of my colleagues, and I talked to a man who runs a pension plan, and he said absolutely, I am in full agreement with same-sex marriage. He said, after all, why should they be spared the agony of divorce? Well, it's true, but what we have to remember is the marriage laws are there for a purpose, and we oftentimes forget what that purpose is, because we get in there and we're really advocating for our client. But the purpose of the marriage laws is to effect an orderly dissolution of the marriage, an orderly division of property and debts. And so there are a lot of benefits that come with being able to be married and being able to avail yourself of the family law statutes. So, okay, I probably went over my time. I'll let you guys go.
I'm gonna come up there. Should we turn this off or leave it on?
Oh, we can turn that off.
Well, thanks, Evonne, for that excellent presentation, and thank you, Mike, for organizing this and everyone else who organized this. It's a pleasure to be in your company this evening. So the issues that I'm looking at are a little bit more in nuts and bolts. Really how I practice law in Montana in the area of establishing parental rights for same-sex couples. And as Professor Ford mentioned, I'm just going to talk briefly about 3 statutory schemes that we use. There's the adoption statutes. There's an area where there really aren't any statutes, the artificial reproductive arrangements. Clearly an area where the law is very far behind the science. And then also establishing parental rights for, I call them de facto parents, people who've been functioning as parents, but they don't have any sort of legal recognition that they are a parent. So in the adoption context, there were, back in, I think it must have been in the 90s, there were some very clever legislators who have snuck in little pieces of law into our statutory framework that works for the benefit of same-sex couples. In the adoption arena, the majority of the statutes are very conservative. You have to be a man and a woman who are married can adopt a child together, or a single person can adopt a child. And so to effect an adoption where same-sex partners can both have the piece of paper that says they're a parent with the legal rights, we usually proceed under what is the section of the adoption statutes that's labeled the step-parent adoption statutes. And there's a little provision under there that, well, first let me just talk about how those statutes work. If I'm a parent and I'm recognized as a legal parent, and I'm the custodial parent of a child, if I would like somebody else to be a parent of that child also, I can allow that parent to petition to become a parent also if I give my consent, and also if parental rights of any other parents are terminated. And oftentimes in a same-sex situation, there is no other parent. For example, if my same-sex partner and I want to adopt a child, usually one person will go through all of the paperwork to adopt the child, and then the other person gets their legal rights through the step-parent adoption statute. There aren't any other legal rights parental rights to terminate. When I do those kind of cases, I file one petition for the first person. I just call it the first adoptive parent to get parental rights, and then I have another section of my petition for the second adoptive parent, and I ask for a decree to be entered at the same time so that both names go on the birth certificate at the same time. this statute that I'm talking about, it just says, for good cause shown, a court may allow an individual who is not the step-parent, but who has the consent of the custodial parent of a child to file a petition for adoption. The petition must be treated as if the petitioner were a step-parent. So that allows people who aren't married to the custodial parent to adopt. I wanted to just mention that there are some states that permit, their statutory schemes are set up so that a child can have 3 or more, or more than 2 legal parents. I think Alaska, Washington, Oregon, California, and Massachusetts are states that their statutory schemes allow that. So I thought that was interesting. It's not allowed I don't know, I think it might be possible actually in Montana. I think if you had the consent of, let's just take an example. Let's say that you have a man and a woman, they've divorced, and the woman now has a same-sex partner. I think if the ex-husband and the parent agreed that the same-sex partner could be adoptive parent, I think it's possible. I haven't like thoroughly researched it, but I think it's possible that you could make that argument. So something to think about. Does anybody have any questions at this point about adoption?
I just have a question with the step-parent adoption. So the statute doesn't provide you have to terminate the other parent's rights.
It doesn't directly say that.
'Cause that's what you
but
always
the way
do.
It's written up. It's implied.
Mm-hmm.
But I think with all of our constitutional requirements and everything, I don't think that you can add a parent. I mean, as long as a parent is objecting.
Mm-hmm.
But I think if that parent's not objecting, I think it's a possibility. So.
Good.
Yeah. Any other questions? So moving on to artificial reproductive arrangements. So I've been handling a few of these cases lately. Most of the clients are from out of state or from other countries. And the reason I'm involved is that if it's a surrogacy arrangement, the gestational carrier lives in Montana. And so the parental rights have to be established where the child was born in Montana. So the process is different for women than it is for men. For 2 women who want to start a family, it's a little bit easier than it is for men. Typically they use a sperm donor. The sperm donor can be anonymous or not anonymous. There can be in vitro fertilization process or they call it intracervical insemination or intrauteral insemination. But what's really important in these arrangements is that the sperm donor, especially a known sperm donor, is protected with a legal agreement. Because if that person is not protected with a legal agreement that says that they're waiving, or at least the women are waiving their rights to name that person as someone who has to provide child support or any sort of responsibility for the child, then it can be problematic. There's a case like that right now in Kansas. Not much good happens in Kansas in this arena. Yeah. Where even despite an agreement, I think the Child Welfare Office is going after a known sperm donor for child support. So, in Montana, we have a statute that says, let's see here. Oh, it's very traditional, of course. If under the supervision of a licensed physician and with the consent of the woman's husband, a wife is inseminated artificially with semen donated by a person who's not the husband is treated in law as if the husband were the natural father of the child conceived by artificial insemination, and the donor is not. So obviously you're not going to follow those rules in a same-sex relationship, but as much formality as possible in the agreement is a good idea to protect the parties, all parties involved. In that sort of arrangement, in addition to the agreement, and let me just say, if it's an anonymous agreement, usually, an anonymous sperm donor, usually when, of course, the sperm is obtained from a clinic, and the clinic has all these extensive agreements that pretty much cover everybody. So it's not so much of a current concern in that situation. It's really more of a concern when there's a known sperm donor and you're not doing an in vitro fertilization process. So, a home process.
Low tech, no tech.
So, low tech, yes, the low tech, inexpensive processes. Okay. So legally, in these situations, I file a petition for a declaration of parentage and ask. So if one of the partners is going to give birth to the child, so by our vital statistics rules, that person is already going to be placed on the birth certificate as a mother of the child. But I petition for a declaration of parentage for the other partner, the other woman, so that her name is placed on the birth certificate at the time of birth. So before the birth happens, I have a court order that says when this child is born, both women will be placed on the birth certificate. Sometimes it works, sometimes it doesn't, and it depends on which judge you have. If it doesn't work, then your next step is the same-sex, or the step-parent adoption statute. So, yeah.
There's a declaration of paternity that can be used. I guess that,
Interesting.
but I guess that doesn't really apply when you.
Right.
Well,
I mean, it's, yeah, I don't know.
yeah, I think you need the court order. I mean, I certainly want the court order, but how would you use
Yeah,
that declaration?
I don't know. I just know, other unmarried
one.
unmarried couples, if someone
Right.
comes forth and declares they're the father without any, proof or whatever, they can sign a declaration and just automatically get put on the birth certificate. So, I mean, I don't know. I usually go for the court order too,
Yeah.
just because I want notice and opportunity to object and all of that. But there is a form at the state, and I just wondered if anybody had ever tried that. See.
I like that idea.
Simple.
It is simple. I'd be
Yeah.
worried about it, how, I'd be concerned that the department or the vital statistics department wouldn't honor it. But they have to honor a court order because there's a
Right.
little sentence in the Uniform Parentage Act that says whatever the judge orders is the order for parentage, and they have to follow it. So, Shane, did you have a question?
Well, I guess I'm a bit confused, Susan. So for the declaration of parentage, in the case of a same-sex female couple, do you make some affirmative statements that either the father has waived parenting rights?
Yes, thank you.
Okay.
So yes, because I think it's, you can see it as being a situation where, there could be a father out there and, it's an easy way to just kind of skirt that person's rights and get around those person's rights. So I feel that it's very important when I file a declaration to, make both people say in an affidavit that there are no paternal interests. And if they obtain the sperm from a clinic, I try to get a piece of paper from the clinic that shows that that's where it came from. Or if there's an agreement, a donor agreement with a known donor, then I make reference to that agreement. I usually don't put it in the pleadings. And I always do get file a motion order to seal the file from public inspection, which is always granted. But yeah, there isn't really any statute to file it under, so I just go under the declaratory judgment statute and ask for a declaration of parentage and a birth registration order. And it seems to work.
There is 40-6-121 that says any interested party may bring an action to determine the existence of a mother and child relationship, which you apply the same provisions as far as possible, it says, as the father and child
Yes.
relationship. So I think that's all you've
And I
got.
actually do cite
Yeah.
that, yes.
But it certainly wasn't, it was from 1975, hasn't ever been, as far as I can tell, there's no cases under it. But it's
That's
what you got,
under
it's
the
what we
Parentage
got,
Act.
yeah.
I mean,
the
under
Parentage
the
Act.
Uniform Parentage
Yep.
Act, yes. And sometimes I make reference to that statute too and say, you know, that the non-biological mother is holding out herself as a parent. And so it's, the Uniform Parentage Act accords her parental rights. Any other questions? Yeah?
If the court does grant the motion, can, and then the relationship dissolves later, can you get the court to recognize the best interest of the child instead of biological parentage as a motivating factor?
Well, I think once two women are put on the birth certificate, because that's what the court is ordering to happen, that they are legally recognized as parents. So it would be my position that they are parents, and they don't have to try to prove that they are. And if someone tries to, you know, say that they're not, I would say that they waive that argument since they filed a petition supporting that person getting their parental rights initially. So I haven't had that.
I don't know. I have a friend in Georgia who she's a lesbian. She was in a relationship for a long time. They each had a biological child within the relationship, and then when their relationship broke up, the children were split. And it was within Georgia. It's the biological parent automatically gets custody, and it was a horrible, you know, these children had been raised since infancy in the same household as siblings. You know, one was 8 and one was 10, and you know, at one point in time, you know, when the relationship broke up, it was devastating.
And that, you know, and I think, you know, we should really work hard to establish, that's a classic example of why we need to work really hard to establish parental rights of the parents up front and not wait till a situation like that happens. I mean, later in my presentation, we'll talk about the recognition of the rights of de facto parents, and that's kind of the last ditch remedy to address that situation as I see it.
Yeah, I'm kind of curious about the nexus between reproductive rights and the adoptive rights, parental rights, and the legalization of marriage. You know, do some of these complexities and intricacies go away once same-sex couples are allowed to marry? Is that
Yes, I mean, we would all be able to use the same statutes. And it wouldn't be so complex. You know, in Montana, though, I think, you know, parent-child rights and marriage, you know, they don't depend on each other. They're apples and oranges. So I mean, I see that division as being fairly clear, but maybe I should just take that back, you know, to some extent. But I think, you know, establishing parental rights, I think you can do that regardless of your marital status, if that answers your question at all.
I think you raise a very good point, though, and that is, to some degree, these statutes are interrelated but separate, and there needs to be very careful drafting, and we're going to have to define what a child is of a marriage if we have same-sex marriage, because then you have people coming into a relationship with a child just like we do now. You have a child together during the marriage, and I think the definitions are going to be important, and you raise a very good and valid point. It's very complicated and complex.
And that's one of the questions that I'm going to be,
Okay.
that's actually something that I'm posing, is that idea of now we're married and we have that equality, but what is still murky under the current statutes that were certainly written with heterosexual couples in mind and very traditional marriage structures.
Lots of litigation for all the young lawyers.
Yes.
But it's also certainly true that the law, the family law and parentage used to all be connected to marriage, and now it is not.
Right.
I mean, now there are so many heterosexual couples having children together, living in a family unit, and then splitting up. And so we have in Montana lots of parenting plan actions all the time when those people split up, even though they're not married. They don't fall directly into the division of property part of the marriage, but marriage and divorce statutes, but they sure fit into the parenting plan. So in some ways it's more complicated. In some ways that makes it even not so dependent on marital status. What's going to happen to the kids in a breakup?
Right, good point. Shane, did you have another question?
Well, this is actually relates back to the Kansas case, because I know I read a little bit about it, and it was interesting, the state's position in that case, and apparently one that the court bought off on, which was, okay, yes, you have these parents, but we were able to trace back the genetic material to this man, and we're going to make him pay child support because he didn't do it properly. I don't care what the agreements are between he and the same-sex female couple. It's his genetic material, he's the father, and this child has an interest in having as many financial resources as possible, and it's in the best interest, and boom, you're on the hook.
And I'm going to talk about that case too. I can address, if you want to, go for it, but that's part of what I'm going to talk about.
I can wait.
It's really, you know, there are so many different scenarios from state to state. It's very interesting. So getting back to, I just want to move on to, you know, family creation for men, same-sex couples. You know, typically it's a surrogacy arrangement, and there's an agreement between the two men and a carrier, a gestational carrier. There's traditional surrogates, meaning that the carrier is genetically related to the child, and there's gestational carriers who are not genetically related to the child, and they become pregnant through an in vitro fertilization process. You know, typically what you see is use of carriers who do not have a genetic relationship, because that's more, it's more of a legal risk to the intended parents. And so, you know, and I think there are some cases where even if someone signed an agreement saying she waived her parental rights, if she's genetically related, back to the genetics, that you know, she can assert her parental rights. So, you know, again, in Montana, when I'm working on a case like that, and I do have a case coming up with two men, and I'm going to ask the court to grant a pre-birth order. I don't know if the court will. You know, and based on the contract and the fact that we don't have a statutory scheme. Sometimes judges try to push me into a statutory scheme, and I say, you know, we don't have a statutory scheme that governs these type of arrangements, and it's a very different arrangement. If a pre-birth order doesn't work, then I think the next step is to try a post-birth order. Again, it's not based on any statutory scheme, it's based on the contract. And then if that doesn't work, again, you revert to the second parent adoption statutes. And it's a little bit tricky with the vital statistics, because there seems to be some requirement or expectation that the initial birth certificate is going to have at least one woman on it. But our vital statistics statutes actually say that a judge can order a woman's name to be placed on the birth certificate even though she's not the one who gave birth to the child, if there's a court order. So, again, I think that statute was written in the context of vital statistics rules and one hand's doing this and the other's doing that. It wasn't really intended to be connected to any of our parenting statutes.
Do you ever fall back on the statute that says these statutes are all gender neutral?
Oh, good idea. I haven't had to, but it makes sense. Well, I like
it's
the
like
one
in
we were, the
Title I,
provision
right?
with the UPA, Uniform Parentage Act, that we were talking about. I've used that one a lot, which essentially says you can, to the extent you can figure out how to do it, you can apply all these statutes that are designed, that apply to men to women, the holding out and things of that nature. So I wanted to mention that, a lot of states do have surrogacy statutes, a whole statutory scheme that applies to surrogacy arrangements, and the American Bar Association does have a model act governing assisted reproductive technology, so there are some models out there that hopefully someday Montana will adopt. Our Parentage Act is also very, very outdated. And I just also wanted to mention in the context of ART, Artificial Reproductive Technologies, that there's also kind of a push to kind of look at and protect rights of children, because they're in essence parties to all of these agreements and arrangements, but they don't yet have a voice. And there are some states that require that children who are the product of arrangements with donors, that when they reach age 18, they have the right to find out the identity of their donors. And earlier, if necessary, if it's necessary to contact that person for medical reasons. So I think that's also interesting development. Any more questions on assisted reproductive arrangements?
And that's that movie, right? The kids are all right?
Yeah.
Oh, yeah. 160 kids.
Yeah. No, that's a different one.
Yes, and you might also want to make sure that you're not going to marry somebody who's your brother or sister.
Oh, okay.
Anyway. So moving on to I call them de facto parents, the parents who are true parents. They've raised a kid for 12 years. That kid sees that person as their parent, but there's nothing in the law that accords them any legal right as a parent. I call those people de facto parents. And in Montana, we have a remedy based on Section 44, 227, and 228. This is the statutes under which a case called Halstead was brought, and I was an attorney on that case. But the statute is designed to do is to protect those relationships. I mean, and it's very much a remedial statute, a remedy of last resort, because you have to go to court and you have to prove that. I mean, and this is assuming you can't get a parent's consent to have you named as an adoptive parent. You have to go to court and prove that you have established a parent-child relationship with the child, and you have to prove that. Let's see, I'm sorry, I'm spacing out. I didn't bring the statute with me, but that the custodial parent acted contrary to that parent's parental interest. In other words, somehow ceded a part of that parent's authority as a parent to the other person. They allowed that person to function as a parent. And of course, that it's in the child's best interest, and it has to all be proven by clear and convincing evidence. And that's a lot of work to have to, an expense to have to go to court and prove that. But it became, these statutes, some folks decided there was a need for those statutes when there were just a few too many cases where people who had a piece of paper saying that they were a parent who really had not had any involvement in a child's life would all of a sudden come and take them away from the people who were really had been raising them, and decision that really was not in the best interest of children, the situation that you discussed, you presented. I think that's all I have, unless there's some other questions.
Okay, great.
All right, thanks.
Thank you.
Well, great, thanks for having me here. Jeff Wilson invited me to speak 3 or 4 months ago now, and let me tell you, things have changed. And I'm glad Susan did some nuts and bolts stuff, because I tend to be the one who throws out more of the philosophical question. Because think about this, and doesn't give you anything practical. So thank you for that. Let me put a little caveat on here. I'm also going to talk about marriage equality and some of those issues there. And it's a lot of what we're talking about, because that's certainly what's going on. It's what's big in the news. It's the happening thing, and it's really exciting. And it's good to see that. But the caveat I want to say to that is it's not the end-all be-all. It doesn't solve the systemic issue of discrimination against LGBTQI individuals. And it may mitigate some of that, but it doesn't solve that and all the issues that still come along. So there's going to be a lot of work to do, even though marriage equality is an exciting thing that's happening now. So what I'm going to do is I'm going to pick apart some of the topics that I had here, because it dovetails really well with what Evonne and Susan have already done. And I don't want to be repetitive, but I want to fill in some spots. Like Evonne mentioned, 17 states, 8 tribal jurisdictions, and the District of Columbia actually have marriage equality now. Of the 33 states that don't, for the most part, as you saw on the map, they all have some type of constitutional ban or a legislative ban. There are only 6 states that don't currently have a challenge, though. I printed this off yesterday from Marriage Equality USA. It's a 30-page document. It's current up to March 25th. And when you read this thing, there's, you know, March 20th, 2014, this happened. And it outlines all the various challenges across the nation. The only states that don't have some type of challenge to gay marriage or same-sex marriage ban right now are Alaska, Georgia, Montana, as we said, Nebraska, North Dakota, and South Dakota. And Evonne asked me to go ahead and speak a little bit on where we are in Montana and what case we do have going. So there is no direct challenge to the marriage ban. But there's the case Donaldson and Guggenheim, the state of Montana that Evonne mentioned. And it was initiated, I believe it would have been the summer of 2010. And I did help work on that case. I was an intern at the ACLU at that time, and I worked very closely with the plaintiffs to help draft the affidavits and the complaint. And it's the current phase, there's 7 couples. We started with 6 couples, we lost a couple, we filed it with 6, and we're back to 7 now with the amended information. So I'll explain how that happened. So the initial, so Donaldson Guggenheim 1, we can call it, was filed in district court in Helena with Judge Jeffrey Sherlock. And the essence of that complaint was that these 6 couples were being denied equal access to the plethora of statutes in the Montana Code. So the argument was, everywhere you read spouse, you need to read, you know, partner or spouse. The case specifically did not challenge same-sex marriage, the ban on same-sex marriage. In fact, it says right in the case, it's not a challenge to same-sex marriage. It was only a challenge to that statutory scheme. So why it got, so Jeffrey Sherlock did not go with it, and the reason why is because of that lack of specificity. He said you got to bring these specific statutes to challenge, just like Edie Windsor did, you know, in U.S. v. Windsor. Section 3 of DOMA, which says marriage is only between a man and a woman, and defines spouse as a member of the opposite sex, is the only part of DOMA that got cut down in Edie Windsor's case. And that's why Jeffrey Sherlock did not hold for the plaintiffs initially anyway. It was sent to the Supreme Court of Montana and remanded, agreeing with that and said, bring me some specific statutes. So what happened is it's at the trial stage again, the new amended complaint outlines specific statutes. So it takes the now 7 couples and identifies specific statutes that couple is not being afforded equal protection under. So for instance, the 7th couple that's now been added, the new couple, is one of the partners is a police officer in Bozeman. So it is specifically challenging the statute that gives survivor benefits to a police officer's spouse. So that's how that happened. The other things that are challenged are others financial protections, dissolution of relationship protections, end-of-life decision-making protections, that kind of thing, and it links it up with a particular set of plaintiffs. So again, we're at the trial stage, and I'm hoping that by the time we send it up and down and back and forth a few times, it's a moot issue anyway, and we have a decision from the Supreme Court on marriage equality anyway. Now, what's interesting is this ability to get married. Once same-sex marriage passes in a state, either judicially or legislatively or at the ballot box, people are going for it. And you get it, right? There's this huge excitement about we can finally get married. There's people that have been together for 40 years who never thought this would happen. And they're getting married. Gay and lesbian couples are jumping at this opportunity. What we're finding is that in places like Massachusetts, where same-sex marriage has been legal for quite a while now, 65 to 70% of the people that identify themselves as being in a same-sex relationship are getting married. The first year after it passes, as Evonne said, thousands of people in that day after it passes are flooding the courts. So we're having very high rates of marriage in the first year. And let's contrast that with places that have passed domestic partners, registries and civil unions. That's always been one of the arguments is, well, it's just as good. You get all the same benefits. People weren't going for it. Very low rates of registration of civil unions and domestic partnerships, but where marriage has become legal, very high rates of marriage are occurring. But here's my philosophical question that we're going to throw out, and I'm going to use just one example to apply to it. The structure of these state laws, even once we made the Montana Code gender neutral and replaced the he and she's with whatever, he or she or whatever it was that got replaced with, the structure of the state laws when they were written are certainly written and designed with heterosexual couples in mind, family law statutes. So even after we gain marriage equality, there's going to be legal issues that remain. One of the legal issues that's going to remain is there's this benefit that heterosexual couples have under the law. There's a benefit that there's a presumption that if you have a baby within your marriage, you intended to have a baby within your marriage, and you intend for that baby to be your baby, not a third party's baby. That only extends to heterosexual couples when you read our laws. Even in a case, Susan read to you from the Uniform Parentage Act, the artificial insemination law. I'll read it one more time just to remind you. If under the supervision of a licensed physician, and with the consent of the woman's husband, a wife is inseminated artificially with semen donated by a person who is not the husband is treated in law as if the husband were the natural father of a child conceived by artificial insemination. And so the emphasis I place is on the natural father. So this is someone who's non-biological father, but he can be treated as though he is, as a natural father. The non-biological mother is always going to be treated, at this point anyway, as an adoptive mother. So you're going to get full parent and full legal rights, but you're not treated as a natural parent. In the case of artificial insemination, It's interesting because you're usually there, if you're a heterosexual couple, because you couldn't conceive. And yet you get to be treated like a natural father. And so we know that that law, the idea of where does that law come from then? You know, where's the presumption and why does it exist? And I believe, of course, that it's because a man and a woman can conceive. Even though that particular man and woman weren't able to conceive, conceptually men and women can, whereas two women can't. So non-biological fathers get to be treated as natural fathers. Since we're talking about artificial insemination, I wanted to talk to you more about the case out of Kansas so that we see what can happen and how states might apply that law. The case is, it's Kansas's Child Support Division, which I don't know if it's just Child Support Enforcement Division in Kansas or what it's called, but it's the state essentially versus Marotta, and that's the name of the biological father in this case. So how the baby at issue in the case came to be, the child whose support is at issue came to be, is that Marotta answered a Craigslist ad. Literally a Craigslist ad. The lesbian couple was seeking a sperm donor. He made 3 donations that they could set aside and use, and over the course of 3 months, and one of the partners did get pregnant. You know, when we talk about, well, why would you do this in-home method? Even if you know your donor and you're just storing at a sperm bank and you're getting it, taking it home and doing it in-home, it's about $500 a shot. If you're having the physician do it, it's about $3,000 a shot. So you can imagine why someone would do this. Not necessarily why someone would do Craigslist, but you can imagine why. So anyway, about 4 years after the child was born, the lesbian couple split up, and one of the women applied for public funds to help raise the child, applied for TANF and other state funds. That's what triggered Child Support Enforcement looking for the father.
Yeah.
And they sought and obtained a court order requiring him to pay child support, and of course back child support for about 4 years. I think he's on the hook, you know, for $6,000 or so, and so that means he didn't even get popped that hard for it. He must not have very high income because he's only up to about $6,000 after 4 years. Anyway, how the court came to that decision was they took that same artificial insemination law that I just read you, because it's from the Uniform Parentage Act, Kansas has it too, and they kind of worked it backwards. So since the women did not use a licensed physician, working backwards from that law, they said, well, we don't know whether the man, Mr. Marotta, and the lesbian woman who conceived the child had a biological, physical, sexual relationship. We don't know that for sure. Maybe they did. So we're going to consider him the father because they didn't go through and do the paperwork right, and we don't know. And I would say to him, well, you do know because the women told you you didn't and told you what the relationship was. But that wasn't accepted. I would also say, so what? If same-sex couples were given the same presumption upon the birth of a child into their relationship, and of course these women weren't married, they're in Kansas, there's no legal marriage, gay marriage there. But if the same presumption were afforded to a same-sex couple, it wouldn't be an issue, regardless of how she conceived the child. Because that's certainly possible too, right? And that's one of the reasons, another law in Montana, presumption of paternity. A person is presumed to be the natural father of a child if the person and the child's natural mother are married or were married, you know, basically during the time of conception. So again, you get that presumption. So if these women in Kansas could have been married, they would have been married at the time of conception, and if they had the same right under statute as a heterosexual couple that was married, you could just presume the child was theirs. The birth registration statute gives heterosexual couples that same presumption, essentially. That's in Montana Code 50. If the mother was married at the time of conception of birth, or between conception and birth, the name of the husband must be entered on the certificate as the father. It's a rebuttable presumption. Again, you know, we don't know for 100% sure. What's that saying? It's what is it? Is it mother's baby, father's maybe? Something else. Yeah. But if a heterosexual couple is given that presumption. And yeah, we all know that biologically these two women did not conceive the child together, but they're in a relationship together. They conceive a child together through some manner, whatever that is. And so that's my question. That's just sort of I'm using that example for that philosophical overlay of, even though we get marriage equality, you still have laws that are written with heterosexual couples in mind, and you still have issues to overcome, and as practitioners, we have to always be thinking of that. So even you know, don't think it's over. Be thinking for your clients and thinking outside of the box on that, and what are the issues that can still arise, even once marriage equality is gained in all 50 states, and I am operating from the assumption that that's going to be happening here before too long. Thank you.
Anybody have any questions before Julie sits down?
But I want to.
Yeah.
I'll sit back up there. Okay, yeah.
Yeah, really.
I've got a microphone.
Well, this presumption thing is really interesting, and I hadn't really thought about it for a long time. But I thought, historically, maybe it's because I'm older than you, and I've read some cases from a long time ago, I always thought a lot of this presumption grew out of sort of the idea, really old-fashioned ideas in the law that, you know, kids could only be part of one family unit, and not like going back and forth between this house and that house. And so for the interests of that family unit, there had to be a presumption that, you know, that person was the father. So I don't know. And then on the practical side of it, I think, you know, what we really should be doing is looking at what people intended.
Yeah.
And that the statutes really need to start incorporating that concept.
Yeah, I agree with you from a historical standpoint, because I also think it arises out of the need for legitimacy for children,
Yes.
which is where common law marriage
Right.
comes from, really. I mean, common law marriage dates back to medieval England, when you had people in rural areas who the cleric and the priest couldn't come around and get to you before you were already bonded with the family. And so I think that those old statutes, that the origin of the statutes does come out of exactly what you're saying, as well as that legitimating of
Yes.
children. But in practical application today, and, you know, putting it how it's used today, I think it's, you know, it draws a distinction between couples, whether they're heterosexual or a gay couple.
It certainly does.
And you can overcome that by doing all the legal work that Susan was talking about. You can become a parent with the same standing as a heterosexual set of parents, but you have to do all that work.
You gotta do all the work.
It doesn't
you gotta
just
pay the
come to
cost
you
for
with the
it.
presumption, right?
Right.
And so, I think you were talking about your friends, and they didn't do the work, so they didn't get those decrees of parentage, and then you're just out there. So the other reason for the presumption, of course, is because the courts didn't want to go into a marriage and raise those questions of who was sleeping with whom outside that marriage, because again, the policy is in favor of the marital unit. So that conversation by itself is going to divide up that marital unit. So it has all those three backgrounds, yeah. Okay, anybody have anything else for Julie?
Have you seen other states challenge the statutory privileges that are awarded to heterosexual couples in the same way that your case
That
is?
Donaldson did. I don't know the answer to that question. I've never seen it.
And I guess why
Everything-
take that approach rather than challenge the constitutionality?
Yeah. That was, I mean, it was definitely a discussion in doing it. And I won't, you know, I won't say what my opinion was of whether to do it or not, but it was certainly a discussion. And it was just a strategic decision. Yeah. But no, I haven't seen it done, and I did read that whole 30-page document about all the different challenges, and I didn't see one in there that's current anyway, so I don't think so. I think it's a unique approach.
Although that's not too different from what they did in the DOMA case. I mean, they said, here's a statute, a federal statute, that treats.
Oh, okay.
Yeah.
I thought your question was to do the whole challenge to the whole scheme in a general way, not the way it's being done now in Donaldson.
I'm sorry, Carrie, was your question, why did you go after the discrepancy in benefits and protections as opposed to going after the
Gotcha.
constitutionality of the ban on same-sex marriage?
Okay,
That was your question?
Thank you for clearing that up. I misunderstood. I thought you meant, have I seen another state that just went for the whole schema? No. It replaced, spouse with partner. Yeah, definitely. There's plenty of individual challenges on that. Usually around things like benefits, survivor benefits, and that's the most common challenges. Anything else? All right, thank you.
Okay, great, thank you. All right, Emily, not least, but
Maybe it will be
Less.
least since we're close
Oh,
on
no.
time, but that's good since I have the least
we're good on time,
experience.
aren't we? Yeah, we're fine on time.
So hi everyone. Thanks to the ACLU and Outlaws for inviting me to come talk and add a student perspective on serving the LGBTQI community. I'm going to start off with some statistics which show that while we are obviously progressing towards equality, we still have a lot of work that needs to be done. And then I'll speak in very general terms about my own limited experience based on a case. And I say based because I've changed a lot of the facts to be able to speak to you about it, but the general issues remain the same on a case that I had during my clinic. So, in 2013, the National Coalition of Anti-Violence Programs published the Intimate Partner Violence in Lesbian, Gay, Bisexual, Transgender, and Queer Communities Report for 2012. The report documented that 21 intimate partner violence homicides of LGBTQ and HIV-infected people for 2012. That was the highest total ever recorded. The report found that transgendered people, people of color, gay men, and people under 30 were the groups most impacted by domestic violence. The coalition stated that because domestic violence is rooted in power and control and often reinforces gender norms within an intimate relationship, transgendered people are particularly vulnerable to abuse because of their lack of gender conformity. So, in fact, transgendered people are 2 times more likely to face threats and intimidation within a violent relationship, and are 1.8 times more likely to experience harassment. So, while these statistics are obviously a little bit depressing compared to the exciting things that we're experiencing with the move towards legalizing same-sex marriage and parenting rights and those things, it's still a really important thing to address. So according to the coalition, these numbers are likely actually much higher, but transgender people often choose not to report due to fear of compromising their own personal privacy, retaliation if they out their partners, and fear of institutionalized transphobia in the law, such as the myth that women cannot be abusers and that men cannot be abused. So, as you folks know, I'm a third-year law student. Since my first year, I've worked for a civil litigation firm in town as just a solo practitioner with a pretty broad civil practice. However, I came to law school wanting to represent victims of domestic violence. So, approaching my 3rd year, I proposed a clinic to serve victims of domestic violence, sexual assault, and stalking, which was accepted as an independent external clinic, which is how I came to receive a case that gave me some experience in these topics. So the clinic was designed to serve 2 full representation clients and then multiple limited scope order protection clients throughout the period of 10 weeks. It was designed so that petitioners were referred to us after already receiving their temporary order of protections, and we would then represent them in their permanent order of protections. So because in Montana, temporary order protections are usually only 20 days, that was generally a pretty small window where we meet the client and then represent them. So under Montana law, a person is eligible for a permanent order of protection if they are in reasonable apprehension of bodily fear from a partner member or from a partner or family member, or if the person was a victim of various violent crimes that are listed in the statute, regardless of the offender, relationship to the offender. Prior to the 2013 legislative session, the Montana Code explicitly denied access to orders of protection for same-sex couples by their definition of partner, which was prior to 2013, spouses, former spouses, persons who have a child in common, and persons who have been or currently in a dating relationship of the opposite sex. However, in 2013, the opposite sex language was omitted from the statute, which meant that members of the LGBTQI community could qualify for an order of protection against their partners based on reasonable apprehension of bodily harm. So through my clinic, we were referred a client who I met her a few days before the hearing. She explained that she had petitioned for a temporary order of protection against her partner, and it appeared based on the meeting and what we talked about that she would qualify for a permanent order under the statute. I'd gotten in the habit of going home and conducting internet searches on the respondent, and then if anything came up, I'd ask the judge at the hearing to take judicial notice of any criminal record that the respondent might have. I'd also search the petitioner in order to prepare a list of objections, things that might come up in the hearing that I could object to protect the person's privacy. So as I entered this client's name, it came to my attention that while I had believed that she was while she had identified as female, she was actually biologically male. And so the discovery raised a number of potential concerns that I hadn't identified in my initial meeting with the client. My first concern was obviously for her safety. Overall, orders of protection do protect the victim, but in certain situations, they can actually provoke the abuser and raise the level of danger. I knew I had the duty to discuss this with her, and the possibility that the respondent, unaware of Montana law, would try and deny the nature of the relationship in court in order to invalidate her qualification under the statute. Although I planned my hearing strategy around avoiding the topic altogether, I was worried about the potential reaction from the respondent by being outed in a public court setting. I was also concerned that my client wouldn't qualify for emergency shelter should she need it. I was nervous about how to address these issues with her too, as she hadn't been forthcoming about her identity in our initial meeting, and because she'd only met me once. So I continued to prepare for the hearing and met again with the client. We talked about the concerns that we had and determined that she would indeed be safer with an order of protection in place. I also prepared to educate the judge on the change in the statute if I ended up needing to, because I was nervous about that as it was a recent change in the definition. In the end, the respondent appeared but did not contest, and we got an order of protection granted. So while the client received the protection she needed, according to the coalition's report that I had cited from earlier, only 4.9% of LGBTQI domestic violence survivors actually do request orders of protection against their spouses. Of that, 23% were denied, so this was in 2012 again. And as far as my concern for shelter eligibility, I learned later that the 2013 Violence Against Women Act increased access to services for transgendered people by requiring that all domestic violence providers, shelters, and hospitals, which receive federal VAWA funding, implement policies that include and affirm gender identities, gender expression, and sexual orientation, and ban discrimination. So I do think that we're seeing a definitely move towards equality. Obviously, this was a very limited experience I had with these issues, but I think that it'll form my practice in how I recognize heterosexual language within Montana statutes and other things. So it was a very good experience, and I'll open it up to questions.
Yep. No questions? Yeah, we got a couple. You don't get to.
Questions or questions just for me?
Are these questions for Emily or no?
Did the transgender issue come up, or?
It ended up not being a contested hearing, so we didn't have to broach any sensitive subjects.
Did the other side show?
Mm-hmm. Black suits are very scary. That's my theory.
Jason?
We heard about PFMA in our criminal law class, partner family member assault. Does it apply to same-sex couples?
It does actually. So the order of protection statute will actually direct you to the definition of partner under the PFMA statute. If I'm wrong, somebody correct me. But, so actually it also allowed, the change in the definition of partner also allowed for PFMAs to be charged.
So then my follow-up question is, how accommodating would you say the police have been in enforcing PFMA against same-sex couples or toward same-sex couples?
I mean, I don't have any real data on that. I think that the Missoula Police Department does a good job. I don't know if anybody.
Well, Amy actually was nodding her head, and I believe she has some personal experiences. Would that be correct? She would not be speaking on behalf of any official department.
I've been out of the department for over 10 years now, so I
Old information.
Yeah, I can't really speak to how things are now.
I think they tend to conduct training.
It's like where I come from, which is Deep South, the police department was rumored would not take same-sex abuse accusations seriously at all. And so often there was an epidemic of underreporting of these things. And so I was just curious what it was like here in Missoula or across the state.
I'm from,
I actually work at the Coalition Against Domestic and Sexual Violence, and most of the reports we've gotten have been that police are doing a good job, but prosecutors are not. So they're having an okay time getting it reported, but they're having a harder time getting it charged.
Okay.
But that comes down to education about the change in law.
Thank you, sir. Any other questions?
Well, just a comment, in family practice and under the family law section, we also have another remedy for no contact, and it's called a civil no contact order. And it's another, I think, one of those benefits that are available to families. So sometimes we get this case and it doesn't rise to the level of imminent threat, but you've got a spouse who's disrupting your workplace, calling your boss, posting things all over town, and you're not afraid maybe for your safety, but this is very disruptive to your life. And again, that's going to be one of those benefits that when we have marriage equality, that's going to be available.
and I think that you can also get a civil no contact order in a situation where the relationships are or are not present. And I have had a few experiences with them, and I think that they're often a really great remedy where maybe the qualifications aren't met. And the difference mainly is that with an order of protection, you have the ability to call an officer, and the officer will come and remove the person, and you have the ability to report a violation of the order of protection. But with the civil no contact order, it's an order from the court. So in order to enforce it, you have to actually file like a contempt of court charge.
Mm-hmm. You can, you can still call 911, obviously, if there's imminent threat of any sort. But you're right, in order to, enforce the order, you've got to bring it. But isn't that under the marriage statute? Isn't that under the marriage statute? Or is
I
that
actually
under
don't know that it's codified. I don't think it is. I'm not sure that. If someone doesn't know. Is it codified?
Yeah, it is, but I thought it was under the marriage statute.
I am not sure.
I'd have to go look.
I could dig it up,
Look at again.
and I'm at 7%, so I can't actually go look it up. I am hampered by my amount of
I'm at
electricity.
81.
Oh, you're at 81, well then you are free to look things up.
And I will add quickly that another benefit of the civil no contact order is that you have the ability to be a little bit more creative, where some people may still live in the same town and share the same social circles as their abusers. A civil no contact order allows for some creative lawyering and language that can allow those two people to kind of still exist in the same circles if that's suited to the situation.
But one of our concerns, we have a group of family law attorneys. Susan and I, regularly go to this meeting. We meet.
Me too.
And you go too.
Yeah, I go too.
We meet, we talk about these issues. And at one point, we brought in someone from law enforcement to talk about, if you have an order of protection versus a civil no contact order, is that going to be a heightened awareness? Are they going to respond more quickly? And the answer was no. We respond to all calls in order of their priority. So obviously if they got a murder, they go there first. But I think that was sort of refreshing to hear.
It was. Mm-hmm. Seems like that's wrong, though. If you have a murder, it's already dead.
Yeah, go to the other one. There might be a second
Right.
murder.
Impending murder. Now you should come,
murders.
yeah.
And look how cool that is that Emily figured out what she wanted to do her clinic in, and then we didn't have a specific offering, and then boom, got it done. And that's hard to get through.
Yes.
I definitely wasn't alone when I was supervised by some awesome attorneys in town who also kind of pushed it through, so it was a great experience. Any other questions, folks? Student perspective? All right, thank you.
So I did, and of course, we agree, we would never cite Wikipedia. Clear, leave this room with that in mind. You will never write, Your Honor, I learned this on Wikipedia, right? Say, I learned this on Wikipedia, nor will you write that in your brief. And you need to go back and research. Nonetheless, I said to myself, are there any Montana tribes who have issued same-sex marriage certificates? And it seemed like Wikipedia was not a bad place to find that out. So, without a formal citation, there are no Montana tribes on the list of tribes which have issued same-sex marriage licenses. So, on the other hand, there are no Montana tribes on the list of Indian nations which affirmatively do not recognize same-sex marriages. So Cherokee and Navajo, which are, and Chickasaw, which are some big tribes, specifically do not recognize same-sex marriage. The tribes which do, Cheyenne and Arapaho, but down in Wyoming, the Colville Reservation over in Washington, a couple in New York and one in California, one in Washington where I actually was the tribal judge, and then a couple in Oregon. So Montana's law on that is not yet decided, but not a bad way. Part of this is thinking outside the box. Maybe if you want to go get a marriage certificate, I don't know why you couldn't try it in one of our. It's also the case that Montana is slow in some ways, and we have a big list of American jurisdictions which have moved directly to recognition of same-sex marriage, or are partway there, at least in domestic partnerships or civil unions. But when you look, I did a talk last summer, so my statistics aren't newer than that. The thing I found here on my iPad. So lists, it was an international talk, so lists other countries, and we're really kind of ahead of the curve in other countries. The first other nation which allowed same-sex marriage was just in 2000. Anybody want to guess?
Norway.
The Netherlands, it begins with an N.
Yeah, it's somewhere.
Yeah, and Norway is now on the list, but it's not very many. So the Netherlands, and then Argentina, Belgium, Brazil, Denmark, France, Iceland, Portugal, Spain, Canada, South Africa, Norway, Sweden, Uruguay, Mexico, the UK. Here's the Australian rule. Any Aussies in here? Check out the Australian rule. Yes, allowed if one of the partners has had gender reassignment therapy.
Wow.
You know, those Aussies, they feel like they're so open and good to go, but no.
Wow.
Open and good. And so Israel, these countries won't themselves issue licenses, but if you have a marriage performed somewhere where it was valid, they'll recognize Israel, Aruba, St. Martin, and Curacao. Mexico allows, but only if it's done in Mexico. I think they've got the opposite rule. It has to be a Mexican marriage, not the other way around. So really, well, you can see that that's some other countries, but not a lot of other countries. I was surprised. I thought we would be kind of in the back seat, but we're not. And in the African countries, many of them affirmatively outlaw same-sex relationships. So they're where we were 25 years ago. Actually, I was just in Africa, and these two lovely men from America, older guys, traveling together. They've been traveling partners, they said, around the campfire for 18 years, and then they said they were from Provincetown. I was like, yeah, I know your deal. My friend said, how do you know? I was like, how do you not know? But then later I said to them, so you guys are partners, right? And they said, yeah, well, it's illegal here, so we can't let anybody know. I mean, what a scary thing. You go from, Here we're talking about how do we get a legal recognition, but you go back and think, oh, we don't have that at all. All right, so here's a question, my first question for the panel, and then I want you guys to ask questions. What good is this going down to the Missoula City Clerk and registering as a same-sex couple? Right, you can do that now. Sarah, are you laughing?
I am laughing, yeah.
And why?
Just because it's
So Missoula has that now. You can do that in Missoula. What does that get you? Have you advised any clients to go do that? Anybody know anybody who's gone to register?
Well,
I actually didn't check. I meant to check this afternoon to see how many they have.
I think Caitlin Koppel did.
I'm sure
and
she did.
she was the proponent of that. And I think her explanation is, you know, if there's law enforcement called or someone's hurt or injured, they have this register where you can see who sort of your next of kin, your relatives are for any emergency purposes.
Yeah, and so that is exactly it. Plus, there is a formal recognition component, which I think is really important. Sadly, it doesn't accomplish much more than that, but it accomplishes something. So that really is an example of what a locality can do if the overall state isn't quite ready. And I saw, Julie, that you weren't really willing to divulge who thought what about whether you should go ahead and try to get the court to come to declare our constitutional provision unconstitutional and so on. But clearly, right now, the climate is not such that advocacy groups feel like it's a good time to go up. Fair? Good time to go up on the constitutionality. Someday, soon, that will probably happen. Maybe the Supreme Court in the United States will take care of that, and then every state falls into line, so I think that's why some people are waiting. But there's a lot of really a lot of strategic decisions about when you attack something and when you bring something up to the legislature again and see if they will change. The polls are part of that. But if the state climate isn't ready for change, still the locality, Missoula, was ready to go ahead on that. And it doesn't buy you everything, but it's a little tiny step, so there's a lot of little tiny steps.
I think the discussion is just good. You're starting the discussion, you're chipping away at it, and the more discussion, the more acceptance there seems to be. And
yeah. So if you are interested in registering, you should go down and do that, because then more people will do it, and then maybe Bolton will do it, and Helena, and then maybe not Billings, or Shepherd, or somewhere.
Bozeman.
Yeah, Bozeman for sure. Yeah. So really, all these things are chipping away. Okay. Anybody have any specific questions?
Joe, I had a question for Susan. You stated that in order to have the other partner's name on the birth certificate, you would petition. And if that worked in some instances, didn't in others, then you would have your fallback declaration. And I was curious what it was, what factors made this sometimes successful, but other times not.
It depends on which judge you have. It depends on which judge you have. Yes. Mm-hmm. So.
And would it be fair to say, without naming any names, which we are not going to do here tonight, that there is some discrepancy?
Yes, I think there are some judges who just feel uncomfortable about granting relief that's not supported by a statute. And so if there's a statute that they can use to do the right thing, then they're just going to gravitate toward that and make sure they've used it. So, I mean, I think that's how I would explain that, because the judges aren't otherwise really adverse in any way to the relief that's being sought. They just, everybody has their own way of going about it, is how I look at it.
And it's like anything, they're just more comfortable if you can show them a statute and a case that says this is okay to do. And then outside the box, some people are less comfortable.
Yes.
Than others.
Well, I hope for something more esoteric. A little astute judge shopping is in order.
Yeah, I mean, I think there's one judge who's just sort of not comfortable with surrogacies because there's no statutory framework for it. And I think that's all it is, really.
And there's no statutory framework, A, because it's relatively recent, say the last 20 years. There's actually, the New York Times is doing it online, is doing a great series of sort of retro, looking back at important issues, and they just this week have one. Have you seen that on the Mary Beth Whitehead case? It's great.
Yeah,
So look
I
at
have
the
to
New
go
York
look
Times. Just
that
came
one.
out
Yeah.
2 days ago.
Okay.
It's really good. But so it's relatively recent, and then, you know, it could go either way. Yep, we're gonna have surrogacy, here's all the statutes, or we're gonna have a statute that says, no, there's no surrogacy. So if you're not clear which way it's gonna go, maybe you don't want to go up to a legislature which is gonna be unfriendly. And so then we don't have anything to give to the judges. But there are women in Montana who are serving as surrogates. And you've had clients from other countries come to Montana.
I have.
And so then that really adds a layer of complexity. And actually, as I understand, as I remember, because Susan came and spoke on assisted reproductive technology law in family law about a month ago.
Yeah.
Yeah, and one set of men was French, fair enough?
Yes.
And in France, A, they can't get married.
Right.
B, they can't adopt a baby.
Correct.
So all
And
that.
surrogacy is illegal.
Yeah, and surrogacy is illegal. So all of that has to occur here, and then they can go home once it's all done, right?
Yes, and it's a little uncomfortable for me too, getting to the ethical issues. Because, you know, I don't want to go to court and not tell the judge that surrogacy is illegal in France. I don't want to give the impression that I'm, you know, trying to do something legal, but it's not. It's legal here, or at least it's not illegal in Montana. And what's also really tricky is that then my clients want special orders that, you know, aren't the same orders that our court would issue. So, you know, they want a judgment that just says that they have sole custody, or they want some, and they want the, even if it's like a same-sex couple, 2 men, they still want to have a birth certificate that has the birth mother's name on it, because they have to satisfy some requirements for getting citizenship for their child in France. So.
And how do you figure out what those requirements are?
I write my retainer agreements that say I am not responsible for trying to satisfy French law or anything about French law, but the attorneys who are working with those people have to, you know, they tell me what kind of things they want, and I tell them, well, whether that's possible or not. And but it's, you know, I think you just have to be careful that there was one case I ended up taking over from an attorney who was handling it, and he was, it was the same kind of situation, a surrogacy case, but he was trying to get a parenting plan, and the judge just thought the whole thing was very weird, and he wasn't being really upfront to the court, and so then I think the court just got nervous and appointed a guardian ad litem, and it became a huge process. So, anyway.
And were you able to redirect the court to a parenting declaration as opposed to...
I was eventually, yes. But
anyway, anybody have any other questions you came here to hear about and we didn't discuss? Shane?
Since we have a little more time, have you given much thought about, we've talked a lot about Montana law. Have you given much thought about individuals who are married in other states coming to Montana, especially for circumstances like federal benefits or pension plans or any of those issues where I'm a same-sex married couple in California, I want to relocate to Montana. My pension kicks in when I'm 65, I'm 64, and should I die after it kicks in, it goes to my spouse, but now my partner, when we move to Montana, or my husband, when I move to Montana, is no longer my husband. And so will that be used against me?
so their retirement benefits are granted by a company or in a particular state, or?
Company, state, federal?
Well, for federal retirement benefits, it's my understanding that it's not based on where you live, but the state where you got married. So if you're married in any state, you can receive retirement benefits based on your marriage. And you can live in Montana, and it's not an issue. The one area where it's still really tricky is Social Security, right? So.
And why is that tricky? Will you elaborate?
Well, it's still based on where you reside. And I don't know why that is, but it still is. But the current thought is that you should still petition for those benefits because the law might change. So
just to make it clear for those of you who haven't really studied DOMA yet, the normal full faith and credit clause requires each state to recognize and give full faith and credit to the acts, judicial proceedings, and laws of other states. So the old rule has been if I am, and people from Montana who are first cousins cannot marry in Montana, but they can go to Nevada, which allows it. I wish to make a comment, but it seems apparent. They go to Nevada, they get married, they come back to Montana, full faith and credit, they're still married here, they're treated by Montana as if they are legally married. So that was the old rule. Then the DOMA is the federal statute passed by Congress, which says, except states don't have to give full faith and credit to the marital status of people who are married in other states. So that's the problem that Shane is talking about.
Mm-hmm.
So you can go to Nevada, get married, come back here, as long as you're a heterosexual couple, even if you are cousins, you're fine. If you are a gay person who was married in a place where that's allowed, and then you moved here, that's the problem that we're seeing.
Mm-hmm.
So the federal benefits were mostly solved by the Windsor case, which says that the federal government will recognize the law of the state where you were married with this little footnote about Social Security. And I think Social Security is going to come into line. It makes sense to me that it will after the Windsor case. But, and who knows who the president was when DOMA was enacted and who signed off on it?
Clinton.
Bill Clinton. And then right before, like 2 weeks before the Supreme Court argument, which was this last spring, he actually published an op-ed piece in the Times that said, I signed it, but now I don't believe in it. And he really, Bill Clinton said to the Supreme Court, and you should overrule it. So it did with regard to federal benefits, but the part that was not touched by the Supreme Court is that question about, what about the first part that says other states don't have to recognize marriage between people of the same gender, which are accomplished out of state, valid there, come here. So really, your hypothetical applies to two kinds of people. People who are living in, married in a state where that's legal, or even people from Montana who go to a state, just like the first cousins go to Nevada, go to a state where you can legally marry and then return home. What happens? Your question, I think, about like a non-federal benefit. So if California, if the law is about your, or if the pension says you can designate your spouse or your spouse is automatically the beneficiary of your pension, well, your definition of spouse when you got married in California is that man you married. And now you bring him back here, or he will come here, and is he your spouse under Montana law? He is not. Under Montana law. What are we going to do about recognizing the status? Well, you don't have to federally right now under DOMA, at least till that gets returned. But I don't, so what do you guys think?
Well, a couple things. That's precisely the kind of cases we're seeing across the country.
Yes.
And the snowball effect of lawsuits everywhere. And it seems like the prevailing decision is that constitutional bans or bans on marriage, same-sex marriage, are unconstitutional. So the overwhelming decisions are coming out in favor of same-sex marriage. An interesting thing that I saw when I was preparing for this was that Mike Cadis now is the head of the Department of Revenue for the state of Montana. And when presented with the question, he said, I'm not going to second guess someone who lists someone as a spouse. If you file Of course, nobody files jointly in Montana because they file separately anyway. But he said, we're not going to be in the business of checking whether you're a same-sex couple or not. We don't have the manpower and we don't have the ability to do that. And that's his position on that, which I thought was interesting. And then the final thing I want to say is, if I had that case, I don't practice in federal court, but I think I might bring it in federal court.
I agree.
Wouldn't you?
Yeah.
And the subject matter jurisdiction for federal court for that case would be?
The 14th Amendment.
There you go. Yep. We just covered this in
But yeah.
I wasn't calling on anybody particularly, but I was getting ready. So there you go. Yeah, 14th Amendment. So it's a federal question case. That's how you could get, because you would not be diverse because here you are together, the same state, but you for sure would have a federal question that this Montana statute or Montana practice unconstitutional.
Right, and I really think I think the whole full faith and credit thing is so interesting, because I actually think some of the cases in which the court overruled statutes were based on full faith and credit. Did you notice that? Yes. Yeah. And it might be the best way to, I mean, it is hard to challenge the constitutionality of a constitutional provision. I think it just makes justices uncomfortable. But I think if you brought a case that said it's unconstitutional under the Equal Protection Clause to deny my clients full faith and credit when you're allowing full faith and credit to other people who are exactly similarly situated, I mean, I think that's a great case. Yeah. So.
Right, and it's Kentucky and Tennessee that we just had that, those decisions on. So.
But look, what if you are, so we can see from here, well, what do we know for tonight? You don't want to be in Kansas. I think, maybe they were on here, no, I forget. I think it was either Kansas or Nebraska, so that shows how geocentric I am or how phobic I am about the Midwest. But I'm thinking it was Kansas, where they also held a 12-year-old boy who was statutorily raped by his babysitter, who had a baby, and she went on, was that Kansas? Yeah, I think so too. So she goes on public assistance, and that's when these things fall apart. She wasn't going to try to get child support from him, but you know what? Once the government pays out child support benefits in some fashion, boy, they came after that little boy, and he had to pay child support. So Kansas, tough place. But really, the question is, so what if people do move here from California? It turns out, and they're not sure. And we're saying, okay, well, you have to wait because like in 5 years, this is all going to be resolved. I get my pension next month. And what happens if then I drop dead? Who gets it? I knew in California, what's the price of coming here? So there is, and it kind of goes to what Julie was talking about, there are ways to get around the problem, many problems, but they all require privatization, private agreements, doing an extra bit of work. So a lot of times a person can just name anybody you want as your payable on death beneficiary, and it doesn't really matter if you're the spouse. So really that's what you have to do in this vacuum, is to try to come up with formal documentation of some sort of like you were talking about, let's get a decree that declares you to be the parent. Change.
And just to add to that, you'll find more and more employers avoiding or moving to gender neutral language, avoiding the whole issue and just saying, if you're married, you're married. If you're, regardless, place of celebration, we'll recognize it, because frankly, they're not in the business of litigating these issues or defending these issues. They simply just want to provide benefits to their employees and move on at the end of the day.
Although I would just say, my own personal employer, the university system, they had to be brought to heel because they were not about applying, they were not about extending benefits. And that was so frustrating because I had been separated from my husband for like 6 years, and we were only still married so he could get health insurance in the university. And my friends who are gay, living together with people, they've been living together and having children, they can't get health insurance and he can get my health insurance. A crazy world, huh? But now eventually they came around, and I think most employers don't want to have that fight. They just want to pay somebody. and get it done. But once in a while, even Hobby Lobby, they are not going to be interested in paying a same-sex partner any part of the benefits. Right? The people who were just up in front of the Supreme Court on the affordable health care, yeah, I bet they would go right back up. So some employers are all about making a statement. Hopefully you don't take a job with one of them. Any other questions or subjects you want to talk about? One of the advertised subjects was we will answer many of the questions that arise when serving the client's interests conflict with the attorney's religious or moral convictions. Has that happened to any of you?
Your piece. Yeah, should I show them my pleading?
Sorry?
I've got one more visual
Oh, yeah,
aid.
right.
We might have to.
And does it
I
pop
don't know
up?
if we have time for that.
So Evonne brought a,
Well,
It's just interesting enough. You got to put it up there. You brought it.
Absolutely nothing to do with same-sex, oh, it's on, okay. It has nothing to do with same-sex marriage, but what it has to do with is what we face in the practice of law and what we're looking at in terms of just moral and ethical standards that different attorneys have. What I'm going to show you is a response to a petition for dissolution of marriage. This was a 2010 case. It was a young couple. I represented the wife in Missoula, and she was the petitioner and wanted to be divorced from her husband, and her husband's attorney actually filed this as a response to the petition for dissolution of marriage. If you look at lines 18 and 19, he's alleging that even though the wife alleged that the marriage was irretrievably broken, he's alleging it is not irretrievably broken to me, to the children, or to God. But I agree that it is so broken in the heart of the petitioner, and therefore the no-fault divorce law of man is in effect for her. There is no scriptural basis for the petition of dissolution of marriage. In God's eyes, this marriage continues. And then he goes on and on. And this is actually an attorney who's in practice here in Missoula. And I was just shocked when I got this response. And, so what do you do with it? You ignore it. You just ignore it, and then you move on and you try to resolve the marriage. But throughout that case, I was constantly inundated with just very slanderous letters and emails from this attorney directed toward the morals of my client, this young woman who simply didn't want to be married to her deadbeat husband anymore. But I think that what we have to remember is that everyone is human and individual, and we all come from different places and backgrounds. And just like our judges, and you'll find some judges who are very empathetic, and it always surprises me because sometimes it's the Roman Catholic judges who are the most interested in helping same-sex couples, and you might expect it to be the opposite. So we can't really put labels on people, but I thought that I should show this, and it might open up discussion for, how do we deal with people who have a different point of view than we do?
Yeah. Wow.
Yeah,
Have you run into any family law issues with any of the polygamous families out in Pinesdale?
Yes. I've had several polygamist marriages.
I mean your client base. You yourself.
I would love to have. My husband might not, but I have always represented what I consider to be the first and legal spouse, because under prohibited marriages, marriages where you're not divorced from the first spouse are not valid marriages. So that having been said, Ravalli County obviously has a group, a polygamous community called Pinesdale. And it's actually a really beautiful community. I've driven through their nice big houses on acreage, and the community itself, as I understand, is starting to dwindle because a lot of the folks are sort of breaking away from the church, but they still live within the community. But interestingly, the judges in Ravalli County sort of ignore the fact of the illegal marriage. And the big issue is, how do we deal with children? And what I found is that they treat all the children sort of equally and expect that the spouse has to still continue to support those other children. So for instance, if he's got 5 children from this relationship and 5 from this, and I found they generally kind of like this in age, they'll count 10 children for child support purposes and then assign a per dollar value per child for child support. So that negatively impacts that first spouse, but I think the point is children have to be supported. And the other thing I thought was really interesting about that, I went to a settlement conference recently with the first wife in a polygamous marriage, and I was trying to get 50% of the marital estate. And the settlement master came back and said, well, I think she should only get 1/3 of the marital estate because you've got this wife, husband, and this wife. And I actually called around, and one of the other attorneys in Missoula actually was Jane Cowley. I talked to Jane, and she had a case in Ravalli County with a similar issue. And in that case, the judge did do a 50-50 split division of property between the first wife and husband.
So you would want to, in that case, jump on the bandwagon and be the first one out the door.
Yeah, good point.
And I actually know of another case from Pinesdale, I think going on right now, where 2 different lawyers represent 2 different wives, each of them divorcing this guy at the same time. So that actually, if you could join those cases, now you could do a more equitable division of everything. So, and I don't know if he had any remaining sister wives.
There are several with just 2 wives. There are some with 3 or 4. And, it's interesting.
Some of these facts you just can't make up.
And yet so difficult.
Yeah.
Anybody have anything else? Any other questions?
I guess a good one to finish on, maybe be, any advice for young attorneys coming up who see these problems, mainly the rebuttal presumptions in the statutory code you mentioned. What should we do? I mean, should we wait for the Supreme Court to decide on that, or should we be more proactive, talk to legislatures? Any advice?
Well, I guess I look at you all as the young people with the energy to go out and be fighting these constitutional cases, like Julie, and I think that's terrific. My hat's off to all of you who have the tenacity to do that, because it's a long haul. It's a difficult thing.
But it doesn't just happen.
No.
And so I think that is a great question, and I think you have to say, okay, where am I on this, and is this going to be one of the causes that I really want to dedicate some of my work to? And if it is, then I think you have to be pretty smart and start to work with other people who are doing it, so you're not at cross purposes. If there's a strategy about, we shouldn't go to the legislature now because they're going to kill us if we get up there, then you better not be the one who wanders into the committee and ends up with a statute that is wholly repulsive to most people. Are probably exactly opposite from what you wanted. But the law doesn't change. You just ignore it.
And there are opportunities. ACLU, when you had your case, they were calling around and asking for people to write amicus briefs and looking for people to help with research. And so I think you can put yourself out there as being someone who's willing to step in and help. They need help. I did not do that. I was kind of crosswise with you on the third-party parenting statutes. I thought you were going to get that declared unconstitutional. And I would just mention that those third-party parenting statutes, in 1 year, I had to use that statute 9 times with mothers and fathers, particularly young mothers who are addicted to meth. And what I was seeing was these children were placed with extended family members. Neither parent could parent. And I was using that third-party parenting statute as a mechanism to get parenting for people who'd stepped in and actually started to form a parental relationship with these children. It was working very effectively and very well. And then Susan came along, you came along with your case, and that case out of Washington, the grandparent rights case.
The Troxel case.
The Troxel case had...
You weren't wanting it to go up because it was constitutional and you just didn't want there to be a risk of it becoming unconstitutional.
That's exactly right. And so I elected not to participate in the amicus briefing, and I was really hoping it would not rock the boat, and it didn't. So that's good.
And I saw an interview with the attorney who took on Jane Roe in the Roe v. Wade case. It was that decision was handed down January 23rd, 1973, I think. So I was watching this as an interview on the anniversary of. And that attorney, when Jane Roe came in her office and wanted to challenge that, was a very new attorney. She said, I forget exactly what she had done, but she had done, 2 wills and 1 divorce or something. And she took that case on, and you see where that ended up. So, sure, go for it.
And Susan is famous, really, for
absolutely.
true story about famous for lots of things. And, but the Kolstad case, it really catapulted her to national prominence. And it has. And actually, she is a member of the Family Law Institute of the LGBT
Bar Association,
which is a subset. So, and that's an invite-only thing, so that's a big deal. But will you talk a little bit about how you got the Kolstad case? Because in family law, she was talking about how that sort of took over her practice. She didn't really think it was going to be a big case. Made a huge amount of law in Montana. And yet, one person really bore a lot of the brunt. And it took up so much time that the practice in other cases kind of had to go by the wayside.
Yeah, I wouldn't recommend that that anybody really pursue that path, because when Professor Ford asked me to talk briefly about the Kolstad case last time I presented in her class, I told her, I said, preparing for the other stuff was easy, but just even thinking about the Kolstad case, it just gives me post-traumatic stress because it just really did tax me, and it was very hard. It's hard to find people who want to, help pro bono on something like that, and so. And that case went on. Really, it should have gone on for about a year, and we actually had an order. It was a temporary order, but it was an order that my client had a full parental interest 6 months after I filed the petition.
And it just occurs to me that a lot of you might not know, but this is a case of 2 women who were partnered up and one of them had adopted the children, but the other one, the de facto.
Right, they didn't know that the other person could even get parental rights through the step-parent adoption part.
So they hadn't done that, then they break up. That's the issue. And
right, so one has a legal paper saying that she has parental rights and one doesn't. So I represented the one who didn't have the legal rights. So where were we going with that now?
Just that you took that case, made big law, so the judge here went with the person without the paper still had a parental right. Supreme Court affirmed. Big law. This was great.
But it was 6 months. We had an order, and there was ample evidence for that order in that first hearing. But then this is back to we got 2 new attorneys on the case. One who has a reputation of arguing every single thing that she can and sucking her client of every single penny. And the other was an attorney for a religious right organization out of Arizona. So the 2 of them then kept me busy just about every week for a year with various legal maneuverings, and I mean, it just, you know, and all anti-gay, all this religious overlay, and so, you know, and the thing that irritates me most about the legal system is how that's allowed to go on, but there's really nothing you can do about it except endure it, I think. But I tried to find big organizations to help me, but nobody wanted to be in the trenches. And what I should have done, my error, was not to go find people like you who are just private practitioners to help me out a little bit more. And there were some who did, like Cindy Teal helped me out. There were a lot of people who helped out. And then as the case got bigger, there were more and more people who came in more on the ACLU, yes. And I have to give Betsy Griffin credit, because Betsy helped me a lot, not as ACLU, but personally on that case, so.
So great, exciting opportunities to really advance the law, but it's not at no personal cost. But I think you guys are right. Newer in practice, you've got less experience, you haven't done it so much, it's a little scary, but you've got the energy to do it, and that really makes up for so much. I mean, even just looking at what you did was just so cool.
Fantastic.
Yeah, so I wouldn't be as scared of it, but I would be strategic. Anybody else?
Well, and
look at
just
Julie.
know that the bar, we have a terrific bar, and we are all mentors, and you can contact me, and I'm serve as part of the state bar mentoring program, and I think most attorneys are really willing to help you work through some of those things, so don't hesitate to call on your elders.
Julie's been in practice 3 years, got out, started her own firm.
2 years, really, 2, yeah, really more like 2.
And what's the name of your firm? I didn't say it.
It's Montana Legal Justice,
Montana Legal Justice.
I started it with Jennifer Guttori from ACLU.
Right.
Yeah.
So, with a specific idea that that's the kind of work she wanted to do. And you're making a living.
Oh, yeah.
Anybody have anything else? Mike, anything else?
No, that's great. Sounds like it's a tough road to hoe.
But rewarding.
Absolutely.
And you make a big difference in people's lives. So. And you know what? I think we've really earned our 2.5 hours of credit.
Yes.
Nice. Thank you all so much.